Good morning, everyone. Thank you so much for joining us for today's Case Metrics webinar. We're excited about this panel discussion with Judge Wong. We have Jeff Shiver and Alan Hamilton of Shiver Hamilton and Bill Casey of Swift Currie. These people don't really need introductions, but very quickly, Judge Wong was elected judge of the State Court of Dekalb County in 1998. I think lots of you have been in his courtroom. Prior to being a judge, he actually had 21 years experience as a corporate and trial attorney. So he has a really unique perspective, a broad perspective to share with all of you. All you guys know Bill Casey, partner at Swift Currie. He has 35 years of trial experience and has actually tried over 100 cases to a verdict. So he's a good person to talk to us about these topics. He also has had some high-profile appellate cases, which I'm sure you're familiar with as well. Today, Jeff Shiver is going to serve as our moderator, and his law partner, Alan Hamilton, is also on the panel. Their body of work speaks for itself. Anyone who's been in the Case Metrics database has seen a lot of their 7- and 8-figure cases, which seem to come in at a pretty regular clip. When you see 40 plus cases that have resolved for $1 million or more, you know that this is not luck. These guys have a lot of skill, and we're seeing verdicts come in with these guys in the $20 to $29 million range. So that's why a lot of people refer cases to them. I understand that they have recovered over $300 million for their clients just in the past 3 years, and the pandemic certainly hasn't slowed them down. At this point, what I would like to do is hand it off to Jeff Shiver, but just a second while we're letting more people join, let me just talk about a couple of housekeeping items. If you have questions during the webinar, we encourage you to log those in the Q&A that you'll see at the bottom of your screen. If you have technology related questions, you're not able to link up to the webinar, you can't hear, things of that nature, if you'll log those under the chat button, we have someone from IT standing by to help you with those things. So without further delay, I'm going to hand this off to Jeff Shiver, and thank you very much.
Thank you, Kim. I appreciate it, and I certainly appreciate the opportunity to be a part of this discussion, and I'm grateful for all the panelists who joined us. What I'd like to do is ask you, gentlemen, we have the judicial perspective, we have the defense and mediators perspective with Bill Casey, and then we have Alan Hamilton from the plaintiff's perspective. I'd like to ask a little bit about how have you been able to settle and resolve cases during the pandemic? For cases that haven't settled, how have you been able to make progress on those cases with litigation somewhat slowed due to the logistics of a pandemic? And then lastly, with what we hope is light at the end of the tunnel, just this week, there was a jury verdict in Hall County in a medical malpractice case. So we know that some counties are able to host jury trials, and we see a light at the end of the tunnel. I want to spend as much time as we can on post-pandemic jury trials and what we think that may look like. Judge Wong, let me start with you. Can you briefly just walk us through how has the court handled the evolution of the pandemic from a judicial perspective? We're almost a year from the first judicial emergency order shutting down jury trials. Can you briefly walk us through how you handled it initially and kind of what you guys have learned through the process and the evolution from the court's perspective?
You're on mute, Judge.
Sorry, our favorite phrase now, you're on mute. I wish I could say that to my wife more often. I think the judiciary, you know, we're a very old institution, very traditional institution. So when the shutdown first happened, everybody was just like at total standstill. Nobody knew what was going on and how to react to any of this stuff. I think our Chief Justice has just done a tremendous job. Justice Melton has done a tremendous job in leading us through this. So he configured this emergency task force, and we meet every Monday there are just so many moving pieces to the judiciary, you know, on the criminal side, on the civil side, tolling, time limit, statutes, speedy trial demands. All of these things have to be worked through. And he led us through that. When we meet every week, we have different committees. Justice LaGrua was in charge of a lot of the task force operations side of things, and Judge McCullough from Forsyth County's chief judge, state court chief judge up there, he was in charge of the civil side. So we worked through a lot of this stuff, just processes. And I think the thing that the bright light that comes out of all of this is the adaptation to technology. You know, courts are really bad at that, but we had to ramp in a hurry. So now everybody's spending a lot of money on IT. We're doing things on Zoom and so on. So I think the transition has been smooth. We had time, you know, because of the shutdown. So it's been well. I think certainly kudos goes to the Chief Justice.
Thank you, Your Honor. We appreciate that. Alan, let's ask your perspective from the plaintiff's perspective. You know, plaintiff's lawyers and their clients don't get paid unless you resolve a case. And without jury trials, we all know that really focuses the mind, as they say, particularly with carriers who might be looking at a trial next week, next month. Are you able to resolve cases? Were you able to resolve cases during the pandemic? And if so, what was your strategy?
Well, I would first of all echo what Judge Wong said, in the sense that at first it was a shock to the system for all of us. And we sort of faced this grinding to a halt of most of our cases, and our offices are shut down, and we're trying to adapt to remote working and how to have accountability within a law firm for that. And then, of course, all of our defense brethren and sistren are doing the same thing. So there certainly was a lull in it, but I think our success in continuing to move cases stems from something I've always tried to do, which is triage cases all the time, every single day. And you typically, when we have trials, you're asking, how do I either get this case ready to send a demand that merits serious consideration and payment of limits or fair treatment, or B, get the case stipulated and put on a trial calendar. Well, B is kind of off the table for the last year. But if you dig a layer below that, at the end of the day, insurance companies and plaintiffs' lawyers and our clients and their clients are trying to evaluate risk. And there is a sense in which, and I've had candid conversations with defense lawyers who I almost all of them I get along well with, and we have, you develop mutual respect over a career, and you can call them and say, Bill, listen, where do you see the fault lines in this case? And usually we see the same fault lines. There are oftentimes one or two or three issues in a big case that make a big difference. Oftentimes I find in the type cases we handle, some complex cases, not always your run-of-the-mill, straightforward rear-end car wreck. There may be two or three evidentiary issues where I'm convinced some evidence is coming in or staying out, and Bill's equally convinced on the other side of that exact same question. And when we identify those things, one of the strategies that's really helped us get to the table to meaningful negotiations is to identify those and then call the court. Once things got going again and we all got used to Zooming and all of those things, we have had several cases where we've said, all right, we've got this impasse. And part of it can relate to an insurance carrier saying, look, I'm going to collect the float and keep my money until you get a jury trial. And I can't completely resolve that issue. I can have candid discussions about what that COVID discount may be. But what we've done is tried to get hearings. And I found judges have been very amenable to, if we communicate clearly and we cooperate with the other side and we said, Judge, we've got two motions in limine that may make a big difference in our ability to clear this case off your docket. Can we get in front of you either in person or via Zoom, get a hearing, and really fast forward something that in the past, motions in limine and evidentiary questions, we often kind of deferred until the run up to trial. But you don't have to. You don't have to. So we've had good success resolving some thorny issues by clearing the underbrush of those disputes about what's coming in or what's not coming in, which then facilitates a more meaningful mediation and has allowed us to get close to full value, and at least identify if there's a COVID discount and let our client decide whether they want to take the COVID discount or keep waiting.
Thank you. I appreciate that. And following up on that point, Bill, I know you do a lot of mediations and are a defense lawyer. Alan mentioned the term COVID discount. Do you, our suspicion has always been during this pandemic that, the insurance companies do want to use this either to delay the settlement or get some form of discount because jury trials are not a tool right now in the plaintiff's arsenal. Have you seen that in your practice as both a defense lawyer and a mediator?
I have, Jeff, and really there's no truer statement than there's nothing quite like a trial calendar to get the interest of the lawyers and the carriers. Now, I mean plaintiffs' lawyers and defense lawyers, because that's when we know that the end is near and it's time to get serious about trying to settle the case or try the case. So, so yes, to the first question you presented earlier, I think the lack of trial calendars has been a deterrent in some situations to settlement, but in other cases, it has enhanced the possibility of settlement. Now, it depends on the case. If I've got a case where we're only $10,000 apart on the rear end, car wreck case, then I think the lack of ability, the inability to get that case to trial, it works in favor of the carrier and the defendant, because if we sit on the demand that we've made, we think it is a reasonable demand, but probably not quite as much as we would pay if trial were imminent. They're going to come around and accept that offer. It happened yesterday. I had reported to the carrier, we're at 65, they're at 75. I sense that if we just sit tight on this offer, eventually it will be accepted sooner rather than later, and that happened. Now, on the larger cases that you and Alan are involved in, and many others that are either defending or presenting that are listening in today, you're not going to take advantage of COVID and the lack of a trial calendar on a case where you're $1 million apart. So I would say no to that. It just really depends on the case. The run-of-the-mill trip and fall, relatively low exposure car wreck cases, yes, COVID is going to work to the benefit of the defendant, and they're more likely to get that case settled at their price. The larger case, not so much.
Interesting. Well, I appreciate that, Bill. Judge Wong, question for you. My good friend Kay Perry out in Carrollton has had some success with encouraging the defense to agree to a bench trial. Have you seen an increase in bench trial requests from the litigants in your court?
No, none. I think it's sort of unique to the judge. For me personally, I'm not a big fan of bench trying injury cases because, it's a damn if you do and damn if you don't. I'm the one who ends up getting blamed one way or the other. So, and my experience has been most plaintiffs' lawyers and defense lawyers are not so willing to let the judge make that damage decision. They want a jury to do it. So I have not had an increase in demands for bench trials.
Okay, thank you. Bill, can you give us some insight for those plaintiffs' lawyers that are participating in today's webinar? What strategies have you seen, short of, say, agreeing to a bench trial? What strategies have you seen the plaintiffs do to try and get over that COVID hump on those cases, like you say, the run-of-the-mill slip and fall, low exposure? Have there been any strategies that have been successful with you or your clients?
Well, and from the plaintiff's lawyer's perspective, I think my suggestion is do what good plaintiff's lawyers always do. Start working your case up for trial from day one. Get your medical evidence ready, be that testimony or illustrations. Depose the key parties, the key witnesses. Send the message that this case is going to be ready for trial as soon as we get back in the courtrooms. That is always something, you know, I always look at two things when a case comes in. Of course, you look at the whole case, but two of the more important things I want to know when I'm pricing a case or I'm mediating a case for somebody, who's on the other side, and is that lawyer someone that we know will try a case, willingly try a case, or is that lawyer someone who will try a case only if they absolutely have to, or is the lawyer on the other side someone that probably is not going to try a case? Are you a trial lawyer or are you a settler? And I want to know that right up front. So when I know that and I see that lawyer working up their case, that sends me the signal that I've been conveyed to the carrier, this case is for real, they're serious on the other side, we need to get serious about whether we want to settle the case or let these 12 strangers decide it for us. Does that make sense?
Absolutely. Absolutely, it does. Alan, on that topic, during the pandemic, has there been any opportunity for plaintiffs' lawyers to do what Bill is saying? Has the pandemic affected the way that you work the case up, that you proceed as if you are ready and preparing for trial?
Yes and no. Certainly initially it affected things a lot. We have pivoted to doing exactly what Bill said. We take our cases and do everything we can to get them ready so that as the dust hopefully settles, as we start to, I actually got a special setting in South Georgia for October just last week. We got a case that we've been trying to get set, and we've been working steadily to put the pieces in place to get the depositions done so that when we could get in front of the judge, when we saw light at the end of the tunnel, we could get the calendar out and say, can we get a special setting for this case? And so I have a lot of cases that we've worked over the past year to put in that position. So for the most part, after we regained our wits, you know, sometime last spring after the shutdowns and the stay home orders and all that, we said, well, let's triage our cases the way we always have, and let's power through with doing depositions, seeking hearings, filing briefs, you know, having conversations with the defense lawyer. What do you need to do? I just refuse to let it sit and keep calling and keep asking and get scheduling orders so that if I know they're going to file a Daubert motion and I know they're going to move for partial summary judgment on part of the case, force the issue, force it to be filed, force it to be briefed. I found uniformly judges have been very amenable to hearing things and trying to work to clear or make their docket as efficient as possible. I mean, they're going to need to help us resolve cases so they don't have 1,000 of them backed up at the end of that. So we've tried to put them in position to be ready is the best way to say it.
Jeff, let me just add something real quick to that. The lawyers that I suspect are not interested in trying their cases are the lawyers who took advantage of, not in a bad way, but took advantage of the stay and did not respond to discovery until he absolutely had to, did not take any medical testimony for use at trial. They let their cases sit. And those are the ones that I'm relatively sure are not going to try their case.
I also chime in here on what Alan and Bill are saying. You have to understand, when we go back to quote unquote normal again, there's going to be a ton of cases. Everybody's in the pipeline. Everybody says, well, I'm ready. So the ones that have really gotten ready are going to get the attention for the trial judge. If I only have X number of days or X number of jurors available, I'm not going to put a case on the calendar that doesn't look like it's ready. And I'm not going to put a case on where there's a lot of motion issues and that have not been addressed. You have to think about the loggerhead that we're dealing with. If you all do what Alan was talking about and what Bill was talking about, resolve all of these strictly issues along the way, then the case is truly ready for trial. So when the judge says, who's ready, you can jump up and say, Judge, you've dealt with everything that we need to deal with. We just need to pick a jury and try this case. Okay, now it does two things. It gets you in front of the judge in a hurry. And two, it gets settlement discussion going again in a hurry. So I think those are very good advice, that don't sit on your case just because we have this law. Work it. In fact, work it harder, because judges will truly appreciate lawyers that resolve all these issues. Because, you know, if I'm looking at a big trial calendar already, and then I have to sit in the office and read your briefs and try to decide how to rule on this issue or that issue while I got trials going on, it's just not going to happen. So it's not an advantage to sit on it. I would truly encourage everybody to follow what Alan and Bill says. Work your cases early and hard.
Judge, I appreciate that. And I want to step out of my role as a moderator and also reiterate all of your points. From the plaintiff's perspective, it's rare that we see the defense slowly putting the bricks on the wall. Usually the plaintiff's lawyers are the ones that are pushing the case. We're finding the witnesses. You know, good lawyers like Bill, for example, might get to a witness first. But a lot of times the reality is, and this is not to disparage our defense brethren, but they're slammed. They've got a lot of files. Sometimes they don't have permission of their client to paint the corners like you sometimes need to do. But when we see those defense lawyers doing those things that we know only matter for trial, it's somewhat unnerving. And so if the reverse has to be true, Bill, I'm sure, can tell intuitively the difference between the lawyers that are just pushing paper and the lawyers that are actually moving the ball closer to the goalpost. And that motivates. And that's certainly been something in our practice that has been successful to either get the case resolved for the appropriate amount, or if it doesn't, you're ready for trial. The wall has been built, you're ready to go. Let's switch gears, because we've got a number of great questions, and I know a lot of folks want to hear about life after the pandemic or jury trials post-pandemic and when they start again. Judge Wong, I know you have some interesting thoughts on that. Let me first ask you in general what y'all have discussed in the committee that you're a member of, and kind of some ideas. And then Andy Rogers, a friend of mine and great lawyer, plaintiff's lawyer, has asked a question about high-low agreements and whether that may affect your willingness to do a bench trial or any other strategies for trying a case with a high-low agreement.
I was just reading Andy's question, and that's a great segue to what we want to talk about. I've never really thought about doing a bench trial if I knew there was a high-low. So the question to me is, are you going to tell me what the high-low is? Probably not, right? So then you wouldn't want me to be influenced, because I would just split the baby and go right down the middle and say, okay, we're done. I'm just kidding. But that's a very interesting thought. I mean, if somebody tells me there is a high-low, I might consider doing a bench trial. I really would. And the other thing about this bench trial business or high-low agreements, and as we were talking yesterday when we were preparing for this panel, is the idea of going with a jury of 6 as opposed to the traditional 12, especially in these bigger cases when you have high dollars involved. When you have a high-low agreement and you can't quite get to the number either side want to be at, and you have to have a trial, I would suggest to you, at least in the state court, that your chances of getting a trial with 6 jurors are a lot better and a lot sooner than if you did with a jury of 6 or a jury of 12. It's just logistics, because, you know, everybody wants jurors. And you have to remember, jurors are folks out there that hadn't worked. A lot of them haven't worked in a while. They're back to working. They have a life. They may not be vaccinated. So all of the precautions that we have to take are still in place. So the courthouses we got to keep social distancing, wear a mask, you can't see people, you can't hear people, logistical problems that we all are very familiar with now. And there is a huge backlog of serious felony cases. And those are going to get priorities everywhere. Okay? So for civil cases like what we do or what y'all do, the personal injury damage cases, you're down the list. Even when we start trying cases, it's not going to be, oh, I'm getting ready to go to trial tomorrow. That's just not going to happen. I know here in Dekalb, we're talking about not starting up soon as until the end of May. And that's going to be another 30 days to give everybody heads up, summons is out, and so on and so forth. So we're talking realistically June. That's summer before we start. And there's 5 murder cases already scheduled. Okay, in the courthouse, because of the way space are configured here, we're limited to the number of people we can bring in for jury service. So, you know, realistically, you're looking at maybe fall, spring, before anything meaningful can happen. So, but if you tell me, I can go with a jury of 6, Judge, I might be able to find a panel of 18 and go pick a jury. And especially if you tell me I have a high-low agreement, or I will agree to cap based on coverage, not just 25,000. So let's say defense thinks I got $1 million policy. I don't want to get hit bigger than that, but I'll go with 6 if you will, plaintiff, if you agree to cap your damage to $1 million. What coverage is? Now, if y'all can agree to that with 6, the case is going to get a little attention. So,
Bill, how does that strike you as a defense lawyer, either having a bench trial with a high-low or your clients agreeing to a jury trial of less than 12?
You know, if I knew I could cap my damages at a reasonable level, even if it exceeded the statutorily prescribed limit of 25,000 on the 12-member jury trial, I would be comfortable doing it with 6. Tried one with 6 jurors a couple of years ago. Not a huge case, but you know, everybody kind of knows what the top end worst result is. So yeah, I would do that. Now I will say this: I have never tried a personal injury case to verdict with a bench trial. I've just always been leery of that, and you know, maybe that's something I need to have more of an open mind about. But never done it. Would I? Depends on the case. Certainly something you've got to get the carrier and the client to go in with their eyes wide open, knowing that a bench trial, you know, who knows what a judge would do with a particular set of facts and injuries. I just don't know. Of course, that's also true with a jury most of the time too.
you know, Bill, that's a great question, because I was thinking about this. It's good and bad, you know, because if a judge, like somebody like me who's been seeing these cases for 20 some years, sometimes raise very skeptical eyes to claims. And sometimes we see nuggets where the other side doesn't. So really, it's sort of like no different than the jury. You know, you take your chances. You persuade and you do the best you can, you know, put the lipstick on that pig that you got and see what happens. And so I'm actually enamored with this idea when there's high-low, when there's a cap to coverage, to do a bench trial. But, you know, who knows? I shouldn't say that because I'll get a bunch of bench trial requests I'm going to deny.
Alan, how do those two concepts strike you as a plaintiff's lawyer?
You know, I love the idea of having bench trials in a lot of different cases. I think the conventional wisdom is that a bench trial probably caps outliers on either side. From our perspective, we sometimes worry about defenses that, with all due respect, should not be defenses to cold, hard logic and law, but they are things, that we worry about hooking what if you're a plaintiff's lawyer, you would call a bad juror. So, somebody that might, I'll try to just use an example. I mean, pre-existing condition is a classic one we all deal with. It following the law most of the time, unless your client gets caught lying about treatment of the pre-existing condition, the fact that they had bulging discs at 50 years old in proper context is not really a defense. So I worry more about a jury getting tripped up over thinking, well, gosh, you can't recover for needing surgery when you already had the herniated discs in your neck before, assuming, of course, they were asymptomatic. Whereas I have higher confidence that judges would obviously apply the aggravation of pre-existing condition charge more logically, according to what it says. But at the same time, I do believe I'm giving up upside potential in a lot of cases. But I think it's a fair trade-off in a lot of cases. But what I've also found, and I'll be candid, I've had zero success having the defense, the insurance companies agree to either 6-person juries or a bench trial in cases with significant exposure. So, and it takes two to tango. These are really interesting ideas that I wish I'd thought of first, though, about, going to it with a high-low in place. And a bench trial can be part of the quid pro quo for negotiating a high-low, and so can a 6-person jury. It's just another tactic tool to put in your tool belt when you discuss at mediation or otherwise with defense lawyers, because it's certainly, those are real benefits to both sides when you negotiate that way. So that's a great idea, I think. Mm-hmm. I just haven't tried it. I wish I had.
Well, let's switch gears and talk about what trials may look like when they actually occur, or when you're able to call those jurors in. First, Alan, do you want to be trying cases right now? Are the jurors that will show up the type, in your estimation, the type of jurors you want as a plaintiff's lawyer?
Yeah, I certainly have concerns about it. I think it depends somewhat community to community. I've been in two different parts of, I loved my time. I went to South Georgia yesterday for depositions back and forth, and people looked at me like I was an alien when I walked in a restaurant in the town square with a mask on, which was kind of refreshing, honestly. But I just think not every community is going to be homogenous about this. Certainly in Metro Atlanta, where most of our cases are, in the Metro 5 counties, I do have concerns that we won't get a fully representative cross-section of the community showing up if we had started trials too early. I'm ever an optimist. Maybe it's in my blood as a plaintiff's lawyer, but I'm optimistic that with these kind of late spring and summer and the progress we're making with vaccinations and the numbers, while still certainly alarming, there's still high numbers of COVID cases and deaths and all of those scary things. It's still a concern, but I'm hopeful that with the Chief Justice and the task force and all the great leadership of bench and bar in our state, that we will be in a position this year to significantly reduce the concern about folks not showing up. But I'll be very honest with you. In my biggest cases, I don't want to be the first one out. I do want some data, at least anecdotal, from other guinea pigs who go first to see who shows up, to see what the concerns that are voiced in jury selection. I would love to participate in a voir dire and kind of hear what people say and just see, what the show up rate is. I forgot the right term for that. What rate of people are showing up that get summoned versus pre-pandemic. And some of these things we're just going to have to learn as we go. And the criminal case is going first. We'll be able to probably make some observations of that. So I'm going to keenly watch those things as we resume trials. And hopefully the concern is overblown.
Thank you. Bill, how about you?
You know, Jeff, as Alan was talking, I was thinking of the webinar you and I did about 6 months ago, where we participated with we talked about who might show up for jury duty. This was a jury consultant group that we talked with, and now the material they had gathered at that time, and I think it's been 5 or 6 months ago, so we were really in the throes of the pandemic. But what we were seeing then was that the jurors that were going to show up at that time were going to be my jurors. They were going to be my defense jurors because they're less concerned about COVID than some of the folks that are not going to go get the vaccine. They think that COVID is not real. The wisdom, or at least the conventional wisdom, was at that time, those are going to be my defense jurors. Those are the ones that are going to show up for trial. The way I kind of think about it on a far less intellectual basis is that so many people are looking for an excuse not to report for jury duty even before COVID. Now we've given them, or not given them, but they now have another reason why they might be able to get out of jury duty. And they can make voice a legitimate concern that they're worried about COVID. They don't want to come in and be around a bunch of strangers. And again, the research that you and I saw was that those people are more likely to be your juror in the plaintiff case. The ones that don't want to come in, because if they're genuinely concerned about it, they're more likely to be a plaintiff's juror. The ones that are less concerned are more likely to be a defense juror. And if you think that, it kind of makes sense. And certainly the research that those folks did supported that conclusion.
And as plaintiffs lawyers, we always worry the jury or jurors are going to be upset and think that we are the ones that are requiring the trial to take place. And with those added concerns for their health and safety, I think it's all that more important for plaintiffs lawyers to make sure in their jury selection, in their presentation, that they try to reiterate the point that trials don't happen always because the plaintiffs are being unreasonable. And it reminds me of my first trial with you, Bill, when I put up the amount of money I asked for, and you took your glasses and you looked at the number and you pointed at the board and you said, "Now we know why we're here." And it worked.
Can I chime in on that, Jeff?
Please.
I think from the perspective of the bench, if and when we have these trials starting up again, it's going to look very different. We're talking about not being able to put people in the same jury box. We got to put a mask on, and we got to put face shield on. Those are what I call the forensics. But here's the bottom line. Folks are going to be very impatient because you've asked them to come in and jump through all these hoops to sit and listen to your case and give you money. Okay? They don't want to be there. Even the ones that show up, it's, I'd rather be at work, I'd rather be somewhere else, I'd rather not be exposed, and so on and so forth. So patience is going to be short. So I think from a trial lawyer standpoint, whether you're a plaintiff or defendant, you have to think about a more efficient way to present your case. Save the drama. Cut to the chase. And depending on your personality and the way you try cases, you have to do a serious self-assessment about, is it gonna really take me 6 days to put up this case? That usually is a plaintiff's disease. It's not a defense disease. The plaintiff takes forever to put up a case, and then the defense, they tell you at pretrial, judge, we need 2 days. Or 3 days. And by the time the trial comes, we're finished in 6 hours. We're not going to call this expert. We're not going to call that expert. Okay, because we've heard everything else and jurors are tired. So I think the problem is more on the plaintiff side. You have to assess about how you are going to present this case, even if you're going on trial in the pandemic. I think that's very, very important thing that you need to think about.
Judge, that's great advice in general and specific to kind of the post-pandemic jury trial world. What tools does the court have to, quote unquote, encourage plaintiffs' lawyers or even defense lawyers to move their case along?
A big mouth.
What have y'all discussed either in general in your committee or specific to DeKalb County? We're getting some questions about what it will actually look like. Will you encourage the litigants to call witnesses by deposition or even by Zoom? Are there any plans in that regard for changing the general way that jury trials occur?
Well, in terms of calling witnesses by Zoom, video conferencing or presentation of witnesses is not new. It's been around. We've done it before. It'd be a lot more common now, and people will be a lot more amenable to it. You can Zoom in an expert, especially one that you deposed, but you want some live testimony. I think the technology has made that ability a lot more feasible. But it's not new. So it's been done before, and it could be done now. It's a lot cheaper, actually, because if the judge has a Zoom account, you don't even have to worry about video conferencing. You just tell your witness, get on your computer, log on to this, and then you're there. That's a lot of saving a lot of money in terms of trial costs.
Bill or Alan, do y'all have concerns with most witnesses being remote in a trial proceeding?
I do, simply because I think you lose so much by being unable to watch the body language, not just lawyers, but yours. You don't get to see the shuffling and the squirming in the chair. You may not get to see the folding of the arms. That I think you do lose something. And I think you also run the risk of interference from other people being in the room with the witness if they're testifying live. And just all sorts of things that make me uneasy, that cause me unease about that.
I don't have concerns about it for what I would call relatively routine witnesses. So for example, if in a plaintiff's case, if the police officer is relatively non-controversial and you want some basic facts and it accommodates that individual schedule, I've always thought it's just an abomination to have, witnesses that are not being paid and have no interest or skin in the game sitting in the hallway for hours and hours and hours, or even coming in on Thursday and we don't get to them. We have to say, sorry, a subpoena now, you got to be back here again tomorrow at 9. But here's the caveat to that. I also am a huge believer in, and one of the things we pride ourselves on in our law firm is how fast we try even big cases. We tried a case right before the pandemic, wrongful death case. We put up our case in a day. We had a jury selection, then we put the whole case in a day of trial. So the caveat to what I said is it's okay for mundane witnesses, but the question to yourself is, why the hell are you calling a mundane witness? I mean, if there's nothing significant to be gained from the witness, why are you spending time putting that person up? And so there's where I join Bill. I mean, when it comes to the crucial witnesses, a defense expert, although we've presented experts for years on videotape pre-done, so it's not totally new. And I have to acknowledge that the Zoom is probably no worse for assessing credibility than a videotape deposition taken 3 months ago and showed on a DVD where the whole jury is kind of sitting back, getting ready to take a nap. So those are realities, but I do agree with Bill that when it comes to the live drama of having your key people, your key witnesses on whom the case turns, there really is not a substitute for seeing them and having their full attention, being in front of a judge and a jury, as opposed to in their office where they can look at their email, surf the internet, look at their phone, pay half attention, any of those kind of possible concerns.
Kim, I see you chiming in. I've got one comment on that, and then we'll turn it over to questions.
Okay.
I agree with you, Bill and Alan. You know, there are some witnesses, we do it with doctors all the time, that you can call by video just logistically or because they cost so much to bring to trial. But some of the most effective cross-examinations I've ever seen were live, and you know, seeing those subtle reactions of the witness when they know that they've been contradicted, they know that they've screwed up. I mean, there's no way video can capture that. And one in particular, as soon as the document that gutted the witness came out, the defense objected. There was a 10-minute bench conference, and that pregnant pause just underscored the importance of the testimony. So I tend to agree in most circumstances with the pivotal witnesses. Well, thank you guys for the general commentary. I think we've got a number of questions that Kim would like to ask y'all that the panelists have submitted, or the registrants have submitted, I should say.
Okay, and we've got some comments and some questions, and we'll just take as many of these as you guys have time to attend. Rock Remsen is asking to the panelists, he says, I've had some success sending offers of settlement and stipulations to trial in the spirit of letting the other side know it's coming. And I've settled 5 cases in the past 30 days using those tools strategically. Are you guys seeing a lot of that?
I have never seen in our practice a consistent benefit from offers of judgment in terms of getting it over the finish line. When they came out, I started sending low offers of judgment, kind of a bottom line offer, and then I learned that, you know, when that offer makes its way up to New York or wherever the committee is, they just see it as the plaintiff's offer. They don't, the message that I might have communicated to the defense lawyer that this is my bottom line, I will not go below this. The message never is transmitted to New York. It's just the offer, and then they want to negotiate down from that. But there certainly are other cases where either because of the policy limits or other issues that it can push you across the finish line. But I unfortunately have not seen it as a successful strategy, particularly during the pandemic.
Okay, we have this one directed to Judge Wong, which I think he's already touched on some, but I want to make sure Lee Welburn's question is fully answered. He says, I'd love to hear Judge Wong share his thoughts on how he expects to conduct jury trials and how his mid-pandemic procedures will differ from pre-pandemic procedures that we're all used to.
Oh, I think this is not just me. I think this is for every trial, every judge involved in these post-pandemic trials. It's just going to take a lot longer, you know, especially in jury selection, just simply because of the distancing requirement that you have to follow. And you got to protect the folks, you got to take breaks, you got to, you know, it's just a lot of logistics. It's just going to take time. Now, for somebody like me who insists on picking a jury in an hour, that's a killer. I'm going to have to shoot myself.
Yeah, I was listening to what you were saying about smaller panels, all the more reason to support that argument for sure.
Yep.
In Dekalb, are you guys going to be able to accommodate a full panel for a 12-person jury trial in the room at the same for a general voir dire?
No, sir.
Okay.
Here's what's going to happen. They've configured this for the Superior Court for the felony cases. So this is sort of equivalent of the need of jurors for, say, a big med mal or big products case. Panel of pool of 48, 4 panels of 12. They're going to use 2 courtrooms. Panel of 12 come in, another panel of 12 come in at, and then another panel of 12 come in at, they report at 8, they get up to the courtroom at 10 because of check-in and this and that. Next panel at 1, next panel at 3. So, you know, at the end of the day, you still don't have a jury. Now, for somebody like me who's used to start at 9 o'clock, have a jury by lunch, that's a killer. I'm going to have to take a lot of chill pills. And so it's going to be laborious. And keeping in mind the issue about patience, you're all patients, not yours, but you're all patients. It's going to be a challenge, I think.
Laura Champ, I think your questions have been answered. Just to read your questions fully, have judges talked about having witnesses testify by Zoom in the courtroom? We did talk about that. And do the lawyers think it's a good idea, or do you think you lose something? I think Bill touched on this. I'd be interested in hearing our plaintiff's lawyers' take on whether you think it's a good idea or if you lose something if you're bringing in a witness via Zoom during a trial.
I think we tried to touch on that as well, Kim. It depends on the witness. I do agree that you do potentially lose something.
Okay. And Mecca Anderson is asking the panelists, how are judges ruling on disputes about virtual versus in-person depositions?
I don't think any different. My practice has always been, I leave my phone number for the lawyers. And now during pandemic, I leave my cell phone number for the lawyers. If you're in the deposition, you have a dispute, call me. I will rule on it just then, because I don't want a motion. I don't want to read papers. So call me. I'd rather take 5 minutes to talk to you, and any hour of the day. I'm stuck at home anyways.
Keeps things moving, right? That's great. Some people have just chimed in with some comments. Howard Spiva in Savannah has said, in many rural communities in Georgia, there are no masks and school and events are happening. I guess it's foreseeable that some people are going to show up this way at courthouses too and present some further challenges. Ron Lowry says, the last case I tried before the COVID lockdown happened was done exactly like this. Plaintiff agreed to cap the verdict at policy limits, and both sides agreed to a high-low. We tried the case non-jury, and the verdict came within the range. This also shortened the time used for trial dramatically. So again, just a statement. And Howard Spiva says he's been in Effingham, Brian Bullock, McIntosh, and he sees this. And Kevin Ford says tough on med mal cases where healthcare providers are seen as heroes in the current environment. Have you guys heard some talk about, or what are your own feelings about trying med mal cases in an era where healthcare providers are modern day heroes?
You know, that's an interesting question. I think that's going to depend too on the venue and the jurisdiction and the facts. I would not, I mean, the first jury trial we've heard about was this week, a $3 million verdict for the plaintiffs in Hall County. You know, they were able to surmount that challenge. I think with some careful voir dire and presenting your case the right way, you can hopefully weed out those that might unfairly favor the medical defendants because of COVID. Now, if it's a first responder or something like that, it might be a different story, but your typical ID doctor or something like that, it would not dissuade me from going to trial, but it would certainly be something that I very carefully addressed at the outset in my pretrial theme, you know, creating our themes.
You know, I don't do med mal work, but I would think that might also be something to think about just when you're presenting the medical testimony to support your plaintiff's damages claims. I mean, I think it might work. It might work to help plaintiffs. That is, you know, this guy, this man or woman is a doctor. They have hero status. So I think that could cut both ways.
Well, a lot of that, I think, is going to depend on the discipline of medicine you're suing on. I wouldn't want to bring a case against an infectious disease doctor right now. You know, but if it's a cancer misdiagnosed, it doesn't really have anything to do with what's going on. It's a different kind of case. So I think I agree with Jeff. It's just depending on the subject matter and what you are suing over.
And just like with any number of cases, even pre-COVID, subject matter and that venue and the type jury components that you're typically seeing. And it certainly guides you on whether you want to try a med mal case in that venue at any time. Bruce Barrettman is asking us, do you see binding arbitration as a viable way to bring reasonable closure to a case?
I don't have any comment on that, because if it's a binding arbitration, if the lawyers already agreed to a binding arbitration, they wouldn't be before me. They'd be gone. Case be gone.
And I think I would be more comfortable with a high-low agreement in either a bench trial or a 6-person jury trial than an arbitration. But that could be because I'm just, that's not a world I'm in. We've not done arbitrations. We're limited.
From a defense perspective, I've never been a huge fan of arbitration. I just always am concerned about the split the baby kind of result, and just enough to make both sides equally dissatisfied. However, with a high-low agreement, I probably would be more inclined to go to binding arbitration.
Okay. We have an anonymous attendee who's asking, this question is for everyone who has tried cases during COVID. Have jurors been unusually upset about being called to jury duty due to COVID? And if yes, are they blaming the plaintiff or the defendant? Are you seeing those attitudes come through from people who have had to show up?
That's a question we can't quite answer yet.
Okay. We just haven't had a lot of verdicts in the last year. Let's see. Bruce Barrettman also asked, do you see it is easier to get a case settled if the plaintiff is continuing to receive treatment?
If it's legit treatment.
Depends on the treatment.
Depends what it is.
Okay.
In my view, that usually makes it more difficult, simply because we don't really have a complete handle on the medical specials. And going back to what Alan said, if it's a clear injury, clearly related, treatment is reasonable, and the charges that are being incurred are reasonable, and you can see it going into the foreseeable future, then yeah, I mean, I think that might enhance the possibility of settlement. But if we're talking about, I've got to have 5 more years of chiropractic care or something along those lines, then I would say I'm probably going to ignore that. So, you know, so many times when you have a case and you're getting ready to depose the plaintiff, and then plaintiff's counsel calls and says, hey, my client's having surgery tomorrow, then that doesn't bode well for the possibility of settlement.
I'm going to piggyback onto that one with one of my own questions. What about gaps in treatment? Do you feel those are truly significant as you're leading up to trial and talking about settlement?
If you're a defense lawyer, it is. we try to make a lot to do over gaps in treatment. And to what extent that's effective, or, you know, depends on the length of the delay. How big is the gap? We're talking a year, we're talking weeks. So it really just depends.
I think it depends heavily on the explanation for the gap, and is it reasonable, and can your client reasonably explain it, which are similar but not exactly the same thing.
Would you consider COVID-related issues of people being afraid to be admitted into a hospital and undergo traditional care in this environment we're in to be something that you feel you could sell to a jury as a reasonable excuse for a delay or gap in treatment?
Yes, I recently mediated a case with some very good lawyers out of Savannah, and the defense side the defendant was saying, well, gosh, you didn't treat for 3 months from January to March of 2020. And of course, the plaintiff pointed out that we were in the middle of a worldwide pandemic, which made perfect sense to me. So yeah, I think that the fear of COVID is a very real and legitimate explanation for delay in treatment.
I have been hearing that from a lot of attorneys in our network, so I wanted to toss in my own question there.
Unless your client's Facebook shows they were at Myrtle Beach every weekend during that gap.
Exactly. If they're in a giant crowd of people somewhere else, that kind of kills that argument, doesn't it?
Bill's going to check. You might want to check that as you're evaluating your client's reasonable excuse.
Absolutely. Anandi Rajan has asked, have you seen attorneys use their own issues or fears with COVID-19 as excuses not to prepare the case or appear for depositions?
Only one.
What I have seen from my perspective, evaluating the defense, lawyers that were cooperative and easy to deal with and easy to schedule remained that way. Lawyers that were not easy to deal with, that would never give you deposition dates, they were never available, they were even less cooperative. I mean, they hid behind COVID. So I think it just made, whatever their general inclination was, it had a tendency to make it a little bit more pronounced.
Yeah, that doesn't sound surprising. Let's see, H. Lee, do you experience more plaintiff discovery problems? For instance, defense objections to RFPD and need for multiple motions to compel, and then difficult logistics to get a hearing.
Can I jump in on that one?
Sure.
From my perspective, I think the Zoom technology has made resolving discovery disputes a lot easier, at least from my perspective. Because the first time you see a dispute, or most of the folks, the Judicial Emergency Panel, the Civil Committee has configured a one-page dispute form, discovery dispute form. You're encouraged to use that. After your 6.4, you can't get it resolved. You outline what the issues are in this one-page document. You send it to the judge. You ask for a hearing, okay? Before you file a motion. That gets the thing on the plate quickly. Now, I've always encouraged, at least in my court, the lawyers know, before you file a motion to compel, send me an email, call me. Which Zoom technology has made getting everybody together a lot easier. And then you talk it out. And I would say 90% of the time, those issues are resolved pretty quickly. And sometimes, just because of the setting of the hearing, you'll get an email back and says, we worked it out. So, I think it has made things easier rather than more difficult.
Okay. Doug Dom has a couple of good questions. He says, does anyone yet have any experience with virtual voir dire?
Not yet. Judge West Taylor in Fulton has announced that they're ready to start up sometime in the latter part of April to do virtual selection and in-person trial in their state court. And he's been working on this. So I'd be interested to see how that comes about. I know recently Buck Rogers was involved in a voir dire, mock voir dire virtually. I've watched a little bit of that on the videotape on YouTube Live. We'll see how that works. So, my concern is it's tough enough to get everybody to pay attention to what's going on. If you do voir dire on virtual voir dire, it may be good, it may be bad, because if you're focused on one juror, the rest of them could be on their phone doing whatever. Maybe you won't contaminate the pool that way. I don't know. It'd just be interesting to see how that turns out.
So with virtual voir dire, would all the other jurors be able to hear what each other prospective juror was saying, like you are in a courtroom?
Well, if you're on Zoom, you will. But I'd be interested to hear what the lawyers think from the plaintiff and defense about this virtual selection process.
I would rather be in the room with them. I feel probably more strongly about jury selection than I do even cross-examining crucial witnesses, that there's something about being face-to-face in the room with them to really evaluate their answers, their nonverbal cues, all those things. But I'd rather have a trial. If it meant no trial, now that's a different question. But if I can choose both, I'd rather have it in person.
I agree with that. I think that perhaps a tool that we haven't discussed today, but certainly in panels that I've been on and discussions with judges that I participated in during the pandemic about restarting, there's been a lot of attention on more effective and efficient use of questionnaires because especially like Judge Wong said, they're now going to have to split. They're not going to be able to do the 40-person general voir dire anymore, or at least until we get more distance between us and COVID exposure. And that really does make it laborious and more time consuming. And a way to shrink that down may be in some cases to have a bit more data in a questionnaire that normally would be part of the general voir dire process to streamline what's got to be asked of each panel. Go ahead.
Let me ask you all this. How would you be enamored to the idea, based on the logistics and all that? What if I told you, all right, let's have a trial. Let's pick a jury. I'm going to give all of you 10 minutes per juror individual voir dire. Put them on the witness stand. You ask questions. You got 10 minutes. We'll go through a panel that way instead of bringing everybody in and having to worry about seating them and all that. You got 10 minutes. You ask whatever you want.
I like that idea. I would much prefer that over doing it by Zoom. The thing about seeing them in person, Judge, is that, and everyone else, is that I can't see what they're wearing. You know, I don't know if they've got on flip-flops. I don't know if they're taking the process seriously by coming dressed to court. I can't see what book they might have brought to read with them there that day. So I think there's so much we would miss by not being able to do it in person. So I agree with Jeff and Alan on that. Great idea on the individual voir dire. I think that's a great idea.
I agree, especially if it can be coupled with a questionnaire. And I would also say, though, the Zoom, one of the concerns I have about Zoom is lessened if it's one-on-one Zoom or even very small panels on Zoom. What really gives me the most pause is the idea of having 40 people on a Zoom. You can't even see them all at the same time. You can't see the reaction of Mrs. Jones to what Ms. Smith says, which is one of the main benefits and efficiencies that we've gotten historically out of general voir dire.
You know, one thing that I thought about too, you know, in my paralegal days, one of the things I was asked to do is make as many notes as possible about body language and facial expressions and things like that. I kind of like Judge Wong's idea. If a witness could be safely put in a box without a mask, so you're still able to observe facial expressions, whereas if they were all clustered together traditionally, you might lose some of that because they would have to employ more safety.
Let me ask this while we still got everybody. I know there's a lot of folks attending today, and I appreciate y'all coming. And it's been asked to get our email address and so on. I would love to hear from the lawyers on both sides about the idea of individual jury selection with a limited time, as opposed to a group panel approach. The idea that I floated about, just let me bring one juror in at a time, then I don't have to worry about segregation in the courtroom. Put them on the witness stand. I'm going to give both sides 5 minutes, 10 minutes per juror, okay? Something we can negotiate, so it'll be a finite amount of time, and you ask whatever you want to. At the end of that process, we're gonna go through the strike sheet, pick your jury. Just tell me what you think about that. I would love to hear that, your reaction to that idea as an alternative to the traditional way of selecting a jury and not use Zoom or virtual jury selection. Thank you.
Okay. We really do have a ton of questions on these, and I can relay these to the panel to address some of them later if we can't get to all of them now. One thing I do have on here, one of our attorneys is asking, can the participants get a copy of the discovery dispute form referred to by Judge Wong?
Yes, send me an email. I'd be happy. Actually, that should be on the State Bar website already in the COVID Task Force emergency package. Judge McCullen is chair of that committee. Send me a note, Kim, and I'll make sure I'll find it and send it to you.
Okay, and I did in the
Distribute.
Q&A, I included the names of our presenters today along with their email addresses. So if you have individual questions for them, you'll have an opportunity to reach out to them to do
Kim,
that.
can I ask one question? At the beginning of the conversation, we mentioned COVID discount settlements, perhaps going down. I saw a number of questions. You guys have the biggest repository of settlement numbers in the country. I mean, have y'all seen a change in either the frequency of settlements that are being submitted or the values in, say, 2020?
It's been really interesting. We had record data contribution in 2020, and we just hit another record last month with data contribution, obviously most of them in settlements. Overall, from day one, our data has been 95% settlements and 5% verdicts. Not that we're seeking it out in those ratios, that's what the data tells us. We feel like it's statistically viable because we see it across state lines throughout the southeastern United States. We break data down in a lot of different ways. Obviously, the biggest category we see is always going to be soft tissue from a minor impact, auto accident case. We're not seeing a change in those numbers. We're not seeing people sell out because of COVID. We're not seeing people accept smaller numbers because of these things that they think are happening. Like, the insurance companies are holding it over plaintiffs' heads that they can't go to trial, so they're having to take a discount, things like that. I feel like my lawyers that really work up their cases very aggressively and treat every case in its preparation stage as though they're prepping for trial are still doing extremely well. So I don't know. And you do have different categories of cases. A surgical broken leg case can't be grouped in the same category as a soft tissue case that's chiro only, for example. I do see more and more cases that are not necessarily looking at the medical bills or lost wages as value drivers. I do feel like there's still communication, particularly with our friends in the defense bar, who still talk about, well, I've offered him 2 times the meds, or I've offered him 3 times the meds, and the guy's got a prior. Never paid more than 3 times the meds on that. And the data just doesn't bear that out. We still see large multiples, those ratios between the medical bills and the resolution amounts. So the stats that we ran for the end of 2020, we thought were going to be very different. And the only difference was fewer jury trials.
Interesting. Thank you.
It'll be interesting to watch to see if there's a dramatic change this year, because while we're getting a couple of jury trials here and there, it's not happening yet. Not to the scale, anywhere near the scale we were seeing before. Did that answer your question?
It did, absolutely. Thank you.
Okay, sure. I do find it interesting that people are reporting more settlements, that more settlements are happening. I think people initially were paranoid. They were scared. Oh my gosh, it's going to dry up because we don't have as many cars on the road. We don't have as many people going out shopping on a premises where they can be hurt. The numbers that we're seeing, the numbers of cases just don't bear that out.
If that is a reality, if the lack of traffic or the less traffic on the road and fewer shoppers is indeed going to have an effect on case volume, I think we may not know that for a while yet, because we get lawsuits that are filed from accidents that were a year, 18 months ago, fall downs a year, 18 months ago. So
that's a really I've been in this business for 39 years and have seen the economy come and go. Nothing quite like what we've had in the last year. But I remember in my insurance defense firm days, my senior partner told me one day, he said, yeah, we're in a bit of a slump here, but what we see is people who slip and fall in the grocery store and hurt their knee, who would ordinarily in a good economic climate jump up and be embarrassed and go, oh my gosh, I'm so embarrassed. I should have seen that grape. I shouldn't have slipped and fallen on it. If they are unemployed now and they're having severe financial problems, they might be more inclined to file a claim or a lawsuit than they were if they were fully employed and more financially comfortable. So just kind of throwing that out there, something that we've seen come and go through the years. So it'll be interesting to see how the trends follow for 2021, and we'll release our stats again for the end of this year. And I'm excited to see what the actual data shows us. Anything else, guys? Okay, well, we have gone over about 15 minutes. Do feel free to reach out to the panelists. We want you to do that. I thank you so much for attending. I think this is one of the most practical panels we've assembled. They're definitely talking about issues that are pertinent today, both to plaintiff and defense firms and to insurance companies as well. Thank you to Casemetrics subscribers who have joined us. We appreciate you more than you know. If you're not a subscriber and you want to look inside our live database free of charge for 10 minutes, feel free to email me. You'll find my information in the Q&A. We will navigate it through a quick 10-minute Zoom call. Tell us about one case you're evaluating now. We'll let you look at some data for free to make sure you're settling within that range. Just one way to look at it free one time. If you want to reach me directly, my direct number is 404-849-6422. And thanks to our panelists. You guys are great.
Thank you, Kim. Really appreciate it.
Sure.
Thank you for having us.
Sure thing. You guys have a great day.
Take care.
Thanks, guys.
Great. Thank you.